Okay, let's do some CPL. This is CPL 100.50-1. Quiz or question. Tom will be going to trial in 1 month for a misdemeanor specified in a prosecutor's information. Prior to trial, another prosecutor's information is filed against Tom for the same misdemeanor. In this situation, A, the first instrument supersedes the second. B, each instrument stands alone. C, the second instrument supersedes the first. And D, it is within the court's discretion whether to combine both instruments. And the answer is C, the second instrument supersedes the first. So let's read the back and then we'll go to the CPL. Okay, so the correct choice is C. Although the second instrument supersedes the first, okay, so that's the answer. Any count in the first instrument which charges an offense not charged in the second instrument is not superseded and remains in effect. So basically it's saying that if the second information has another offense outside of the same offense that the first information is talking about, then I should say the first, not the second. So in other words, I don't know what misdemeanors are. I'm just going to say A and B. So first prosecutor's information is A, and that offense A is also in the second prosecutor's information. They both have that offense. Then the second would supersede the first. But if the first also has an offense A, whatever that offense is, but it also has another offense that the second prosecutor's information does not have, then that second offense, B, would supersede the prosecutor information of the second prosecutor's information. This shit is crazy. I can't. Let's read that again. Although the second instrument supersedes the first, here we go. Any count in the first instrument which charges an offense not charged in the second instrument is not superseded and remains in effect. Now, whether that moves the first instrument to supersede the second or the actual charge in the first to supersede the second, I'm not sure about that. But let's just read the CPL and take that at face value. I was too lazy to get the book out, so hold on. I'll pull it up on the phone. Okay, here we go. So this CPL is 100.50 is superseding informations. In other words, superseding, which comes first, and prosecutor's information. So 100.50, superseding informations and prosecutor informations. Ay, Dios mío. I'm going, this is like going to be a pain in the ass. Hold on. It's easier when I have the book. Shit. Why is this blocked? Shit. If any time before entry of a plea of guilty to or commencement of a trial of an information or prosecutor's information, another information, or as the case may be, another prosecutor's information is filed with the same local criminal court charging the defendant with an offense charged in the first instrument, the first such instrument is with respect to such offense superseded by the second, and upon the defendant's arraignment upon the latter, the count of the first instrument charging such offense must be dismissed by the court. The first instrument is not, however, and here's the second part of that, is not, however, superseded with respect to any count contained therein which charges an offense not charged in the second instrument. So let's say there's 2 charges in the first and 1 charges in the second, and the first charge in the first matches the only charge in the second, that would supersede the second. But since there's a second charge that's in the first that's not in the second, now that's going to supersede the second because that charge wasn't mentioned. Okay, then if we go on, this is very interesting, number 2. So it's 100.52. At any time before entry of a plea of guilty to or commencement of a trial of an information, the district attorney may file with the local criminal court a prosecutor's information charging any offenses supported, this is very interesting, pursuant to the standards prescribed in subdivision 1 of section 100.40 by the allegations of the factual part of the original information and or any supporting depositions which may accompany it in such cases. The original information is superseded by the prosecutor's information, and upon the defendant's arraignment upon the latter is deemed dismissed. So what this is saying, that let's say you have the first prosecutor's information and the second prosecutor's information, but there's supporting documents that help the argument, right? In the first prosecutor's information, the second one will be dismissed upon that prosecutor's filing another information, because basically he wants to use that evidence in the supporting documents in the first prosecutor's information in order to get the charge going on this person, the offense. So that's very interesting. That's pretty slick. It's like homeboy didn't even do the work, but whoever filed the first prosecutor's information had that supporting information, and now the guy in the second that filed the second prosecutor's information, he's going to file another prosecutor's information, which will dismiss the second one because there's supporting documents in the first prosecutor's information that he can use to get this MFR. So there you go. And we'll just close it out with the last, number 3. A misdemeanor complaint must or may be replaced and superseded by an information pursuant to provisions of section 170.65. So it's basically saying that an information can supersede a misdemeanor complaint.